Students, today we'll discuss about infringement of IPR. IP infringement is any breach of intellectual property rights. The IP rights are infringed when a work protected by IP law is either used, copied, or otherwise exploited without having the permission from a person who owns those rights. The examples of IP infringement are counterfeiting and piracy. There are several types of intellectual property rights such as copyrights, patents, trademarks, and industrial designs. An intellectual property infringement may for instance be of any one of the category such as copyright infringement, patent infringement, trademark infringement, or design infringement. Copyright infringement. Copyright is only infringed if the unauthorized user tries to use the whole or the part of the copyright work. So in order to take action for the infringement, it is necessary to prove that the infringing party has actually copied the work. So this could be considered as a work of copyright crime. So the infringement of copyright on a commercial scale may be of criminal offense. This activity is known as copyright piracy. So the piracy and counterfeiting are also referred to as IP crime. If the infringement of a copyright work is intentional, if it is on a large scale, and if the copies are made for sale or being imported or distributed or sold or either put on the internet, it is worth to file complaints in the police department or the local trading departments. So they would be able to decide whether to take action against the unauthorized user, and prosecution would be a justified process. Patent infringement. So infringing a patent means either manufacturing, using, selling, or importing a patent product or a process without the patent owner's permission. So the owner of the patent has every right to take legal action and claim for damages. There are some exceptions. Defenses to patent infringement given under the section 60 of clause 5 of the Patents Act 1977. And in general, it is also permissible to use a patent if it is done privately and for non-commercial purposes. So the patent law in European countries include a research exception which permits the use of patented invention for experimental purposes without infringing the rights of the holder. Design infringement. A design right is the one which protects the design from unauthorized users copying it. By registering a design, the proprietor obtains the exclusive right for 25 years based on proper renewal process. A design infringement is one where the rights are infringed by a third party for a commercial gain without the permission of the rights of the owner. The competitor will infringe if they produce a product which uses the same design as the registered design for their purpose. It means that the competitor should not escape being liable for infringement merely by making trivial changes to the registered design. Trademark infringement. A registered trademark is a property right whereby the owner is granted the exclusive right to the use of the trademark. If someone uses an identical or similar trademark for identical or similar goods or services to a trademark that is already in use without the proper permission of the owner's consent, then the party or the unauthorized person infringes the trademark. There are remedies to the owner to prevent an ongoing infringement, including damages for the past infringements. The Trademark Act 1994 specifies the defenses to trademark infringement. So, we have discussed the 4 categories of infringement which is in use, and the next session will discuss about the enforcement measures.